go too far, we're going to start off with this. We are going to start off reacting to the VShojo stuff because I want to get this, focused in on. We out here focusing in on this. Now, when it comes to this, again, Legal Mindset got access to an employee contract over at VShojo. This is not a talent contract. This is an employee contract. And I'm already putting it up to 1.25 speed so we can, understand this. When it comes to this contract, there are some very juicy details that Legal Mindset purposefully has left out from the review of the stream review that he did, that I also did watch, and from this because it does reveal who the person is that gave him this contract. So for ethical purposes and for the purposes of protecting said individual, Legal Mindset censored a lot of that information out. There's still a lot of information here that makes you go like, oh shit, and also makes you look at several of the girls right now and several of the talents that aren't speaking up and talking. They might be under similar restrictions, if not worse. You can take a look at individuals like Silverveil and how the NDAs were also applied on her mother. Yeah, there might be some other craziness in there that we need to be aware of. So I'm gonna pop this up. We're gonna hit play. Make asylums great again. Yeah, I agree, bro. But let's watch this. And I'm sorry, every time I hear his intro, I have to start dancing around a little bit.
The VShojo contract has leaked. Well, a VShojo contract has leaked, and it's very relevant to the current downfall of the company and perhaps the contracts that are being pushed in front of talents right now as they try to negotiate, settle out, and end their relationship with the failed company VShojo. So we're going to be going over that contract today on the Legal Mindset. We teach you to be your own judge. Of course, I'm Andrew Esquire, attorney, and this is something that
I know you're an attorney, but that's also why I like to go to you for a lot of this stuff, because he's an attorney. He's a former corporate attorney. Actually, he might still be a corporate attorney. I don't remember. Thank you for the subscription, Sammy. I appreciate it. But he might still be a corporate attorney, so take that as you will. But he knows a lot more like these corporate laws, these contract laws. He knows stuff that everyday lay people like us aren't so much aware. That's why I do defer to him a lot of the times on these things, and I'm screwing up my lighting right now, so there's that. But the Johnny Somali one was a better one intro. Listen, his Johnny Somali intros are good, but I still love his usual intro.
I love to do going through contracts. It brought me on the VTuber scene going through the Niji Sanji contract. So we've got one today. I've broken it up a little bit differently for this Fast Facts version. Of course, if you like the Fast Facts, like the video and leave a comment below. For the Fast Facts, I'm going to be doing a very, very quick summary of the contract language. We're going to go through all the relevant points, which I've cropped out. If you want a very detailed analysis where we really go into the meat of it, check out the live. That'll be a much, much longer version where I will go into much deeper detail. But we've got the quick version.
His live version where he was going in through much deeper detail was about an hour and 15 minutes long. This video is about 17 minutes long. So he's still going to get you guys fast facts, but there's a lot of interesting things that were in there.
For you guys today, of course, on the Legal Mindset. And of course, we've got a PowerPoint, yes, on the exposing of the VShojo contract. So here we go. The background on this contract, this is a new contract that was sent to me this week. It is for an employee that was terminated from VShojo. Now, to be very clear, I'm saying employee. Typically, most VTuber companies, including VShojo, do not consider the talent employees. They consider them independent contractors or some sort of other non-employee worker. They do not consider them employees. So there are some relevant parts of this. There are some parts of this contract that are not relevant or wouldn't be relevant to VShojo talents necessarily. However, I believe many of the clauses are, including the ones that I've included in this PowerPoint in this presentation. So a lot of the information you're going to see today is absolutely 100% relevant to either what was already signed by the VShojo talent or what they are trying to get them to sign right now. I guarantee.
I don't know if they're going to be trying to get him to sign right now. Again, they don't have a lawyer. They're apparently don't have enough money to even file for bankruptcy. So the idea that they might be having him try to sign these things right now, not so likely. That being said, I will also point out that there are some things that they probably already signed. Again, like I said, there's some of the talents that haven't really spoken up a whole lot, whether that be for the fact that they kind of are taking care of things behind the scenes legally, whether they're talking to their lawyer and they're letting the lawyers do the work, whether they're filing or whatever. But there's some other things that they might actually not be allowed to speak up based on contracts that they have, not just NDAs, but some of the other things that they have signed.
You that something like this is being pushed in front of some of the talents. I guarantee you that some of the talents have signed a document very much like this, similar to this, et cetera, because as an attorney, I can tell you that attorneys are lazy. They like to use templates, they do the same forms. So I guarantee you that a lot of the same language is probably going in front of the talent right now. Now, while this is not a talent contract, I did previously review a talent contract from VShojo. Now, a lot of people asked me to disclose that, to show that obviously there were confidentiality concerns, which there still are today, in terms of being able to identify who that was. And the individual asked me not to disclose it. Therefore, taking attorney-client privilege here, I'm going to say, hey, I'm not going to disclose that information at all whatsoever. But
I still want to see it. I still want to see it. For the love of God, I'm curious who it is.
I will say that I do see some things that are the same, and there's some points that I'm going to point out which are similar to the VShojo contract. So
Umbro of talent contracts is similar to employee contracts. Then there's a very big chance the court will treat talents as employees. There's always a chance that the court might do that. Don't get me wrong, but until we know what maybe some of the talents path forwards legally will be, until we see like maybe what some of their legal actions are going to be, until we get some of those legal filings, we're not going to be quite aware of what's going to be happening where. So I don't know if they're even going to try to take the employee route. It would be a smart idea, but at the same time, we're going to get into this. VShojo's really trying not to deal with that because they actually base their laws out of Washington State. Yeah, their employment laws are based out of Washington State. So the companies in California, business-wise, they're filing out of Delaware, which is common for several businesses out there. But it turns out they're trying to do their employment law out of Washington State, which is different laws to what California is. So there's some interesting things that I don't know if he brings up here, but he did bring up in his long-form stream.
Pay attention to these clauses because these may be in some contracts with talents that you enjoy and that you love and that you follow. And also, there will be private information that is going to be redacted. So you're going to see that mainly in one slide, and that's to protect the privacy. Of course, I respect the privacy of the talents above all because I believe, as a part of the VTuber community, as someone who loves the VTuber community, VTuber fans, they always want to put the talent first. That's something that VShojo was supposed to do, but they failed in that. But you know what? Legal mindset will not fail in trying to protect the talent first.
Bro, if you want, you can go check out his full live stream where he does break this down. But the idea is that several businesses will do this. So yes, they are based out of California, but from my understanding, several businesses will actually try to apply laws and jurisdiction within other countries, not other countries, but other states in order to benefit themselves. So that's actually a lot of what they did here. Was they hired a business attorney out of Washington State to apply those laws onto them. So apparently that is actually common practice. I don't know how this will all play out, but this is actually really interesting, and I am curious how this is going to play out more legally. I know this is more legalese, and as a layman, I have to require the assistance of an actual attorney. But I do find this stuff interesting. It feels like a giant chess match right now, and I'm curious where it all leads.
First. So here we go. This is a separation and release of claims agreement. So this is the form. Now, this is not the agreement for employment. So it's not the employment agreement. This is actually separation agreement. So this is what you would get them to sign at the end of their employment. So why this is relevant right now is because you would want all of the talents on the way out to sign an agreement like this. Some of them may have already signed this and may have already been out. Some of them may have not. Some of them may have refused to sign. They may have come to an impasse. But certainly, most of the employees, which is what we're dealing with today, would have signed this. And one reason why you haven't heard a lot is probably because they signed this. And once you see the clauses, you're going to understand why they haven't spoken up. So this is obviously between VShojo, which is a Delaware corporation. Many corporations formed in Delaware, very common. Now, lately, the Delaware law has been not so good for corporations, but historically, it has been predictable at least. So a lot of corporations are formed in Delaware. And then, of course,
and I did see when this first came out that, oh my God, they're in Delaware. How is this possible? This is common practice for corporate laws. You can hear a bunch of companies actually are based out of Delaware. Some of them have been leaving recently, mainly due to the X lawsuits, if you guys have been following anything on that. So it's not that ridiculous to think of a corporation having it based out of Delaware. That's not out of the realm of possibility.
The talent, which is, or the employee rather, which is blocked out. So you see here, what this does is it says, hey, after this agreement is signed, you're no longer an employee. You can't say you're an employee. This is effectively a termination. So the termination is as of the date of this agreement. So they can argue that before this agreement, they were still employed by VShojo and they were not formally terminated. I cannot say the date, but let's just say it's in the recent past. That's good enough. It's within the scope of time, probably in which VShojo was not paying its bills and not paying talent. I can say that safely because they weren't paying the talent for a very long time. Further, you've got terms like return of property. So this is something pretty common. Many of you probably see this. If you ever get terminated from a job or you have to leave, you probably have to return stuff like your badges, your codes, your laptops, computers, mobile phones, all that other sort of stuff. But the one thing that's interesting to me is electronically stored documents and files or physical files. So an interesting thing is to me, did they require them to send back logs, to send back chats? What was assets? What sort of assets or other things were required to send back? Things that weren't completed, things that were halfway through, things they could have used, because remember, VShojo is unique in that the talents own the IP. So were there things that were almost ready to go to the talents, ready to go to Iron Mouse or Kson or somebody else that they took back? Probably.
I'm willing to, it is a possibility. What he's laying out there is probable that they had assets that they were going to give to some of the talents. What I'm willing to bet when it comes to the electronically stored documents that or files or things like that, I'm willing to bet that's more on the file of maybe some financial records or some other records that they just don't want out in the public and that you probably shouldn't have a hold of. That's where my mind naturally is going to be going there. Maybe some other contracts to help get somebody here or here, maybe some of their marketing. Granted, it also doesn't really shock me that they might have a bunch of electronically stored files and documents, because if you remember back to the Nintendo, Mutant Do, whatever the fudge you want to call his name, he openly said they don't have actual offices. They didn't have real offices out there. So the idea that maybe a lot of people would have these electronic files, maybe a PDF form or something like that, that they need to be transferring back and forth, that they don't really have in a good storage system. Yeah, that actually doesn't really shock me to think that that might be going on. And it might not just be assets for some of the talents.
There's also a bunch of representations in here, which are interesting, that the employee isn't suing them, hasn't filed any claims, hasn't filed any sexual harassment or discrimination or abuse claims. These are very interesting. And also any claims for wages, because we know, and this is a very interesting fact, that separate from all this, there were allegations of misconduct, workplace misconduct. We're talking uncomfortable situations, which could have been based on just what the information out there, we can't say for sure, but could have potentially been sexual harassment or workplace power situations, maybe.
What he's saying right now, and this also goes to, as Ombro calls him, Ish Person 1, because this is being clipped out for a YouTube video, and I'm trying to be at least a little nice here and understand my censoring. There's new information that did come out about Ish Person 1, MTD, that he was very much getting friendly with non-talent individuals in this clip and pressuring them to do some things that are untoward. Now, it wasn't in the sexual manner, I will say that, but it was not okay to be doing, and it revolves around a certain Colombian sugar ingestion that he would pressure people in order to partake in, allegedly, according to this one VTuber. So yeah, if there are power dynamics and power disparities going on, I'm willing to bet it's going from one way. We also have the claims from, I believe it's Veibe's boyfriend. It's either Veibe or Neander's boyfriend. I can never remember which one it is, but Aethel openly talked about how a lot of them would actually force you and continue to force you to drink copious amounts of alcohol. Granted, that was in non, business settings. That would be out at parties and stuff. So some of that might actually be able to take in part here, but also we have had a lot of comments about creepiness from Ish Person 1 and potential bad touches and bad things going on. Again, I do remember that Veibe tweet that she did delete, probably rightfully so, but it's still questionable.
Quid pro quo, some sort of weird situation in the workplace. So this is interesting. So all of those employees that may have been intimidated or harassed may feel, hey, we signed a separation agreement, therefore we can't bring those. Now, the fun fact here, and this is something that should be reminded to many of the talents, is if they truly broke the law, if they truly went out there and committed crimes, committed harassment, labor violations, no agreement is going to protect them from that. And just because they offered you a little bit of money, and we're going to see here the amount of money, That's not enough to buy them out. That's not enough to get them out. So from those type of claims. So let's continue here.
That's also true if they did touch you inappropriately or force you to do anything. Those are always against the law. Again, he goes further into this within the actual live stream itself, but he talks about, hey, if they discriminated against you on the basis of sex, gender, any sort of employment status, your disability, your race, anything like that, you can still bring a claim. Just because you're leaving the company doesn't mean you can't sue them. They're not allowed to prevent themselves from getting sued for any discrimination or any bad conduct.
So here we go. The separation benefits. So this is interesting. For every contract, you have to have what's called consideration. You have to have something of value exchanged. So right here is a lump payment of $6,600, right? Which would be paid no later than 6 days from the separation date or 6 days from the weekend or federal holiday after. So, it's a modest payment. I mean, that's a reasonable payment, not a massive amount of money, not 100,000 or 50,000 or 20,000. Probably about a month, 2 months, or 3 months. I don't know how much they're paid, but a couple months of labor. Typically, most terminations or separations will give you a month or two, and maybe 3 of wages. So that.
If you're let me tackle that right there real quick. If you're getting $6,600 and that's potentially your 2 months worth of wages, if not 3 months worth of wages, you're getting paid about the same amount as I am. And I'm a blue collar worker at one of the bottom rungs of my actual day job. I'm sorry, what the heck were you actually doing there to get paid that amount? And that doesn't seem like a decent amount of money right there. If that's like essentially 3 months worth of payments, that's about the same amount that I would make in 3 months. That's kind of small to compare to what I'm thinking, especially for a company that's based again out of California. Yes, maybe corporate wise, they're based out of Delaware, but this is a California company. Wouldn't you be paying out a little bit more even for your everyday employees just because of the actual living expenses that are required within California? This doesn't feel right when I see that amount of money, and I feel like somebody should actually be getting paid a whole lot more. So I am actually taking a little bit of a umbrage with that amount of money, because it just, that doesn't seem realistic.
Would fall in line there. Also talks about continuing to pay healthcare. And very importantly, at the bottom here, which is one of the reasons why a lot of people sign these agreements, is because they want a letter of recommendation. So what this says here is they will not give a recommendation, but they will confirm employment with the employer. Now, what's interesting here is a lot of people are, they want a good recommendation. They want something coming out there. Listen, it's not worth it from VShojo. And second of all, that's what they're legally required to do. An employer is legally required to just confirm you work there and the dates you work there. They don't have to say anything else, right? And there can be problems if they disparage you, if they say something negative about you, particularly if that's not true. There can be massive issues with that. So while a lot of people want that, they want to be on good terms, they're not giving you much more than is legally required, which
I actually didn't know this, and I'm sorry for cutting him off. He, again, goes deeper into this during his actual live stream. I didn't realize that it's actually not, common for employers to come out here and say even good things about former employees. They'll just say, yes, he worked for us. Because even when they say good things about former employees, that can have negative ramifications. So I actually was not aware of that when I was first going through this. And I didn't realize that companies are legally required already to come out here and say, yes, you worked with us. I never knew that. I was actually unaware. Plus, I haven't actually seen a contract in which they would say anything like this. But I mean, that was just a fun little tidbit that I was unaware of at all. So,
once again, in a lot of these contracts, you think they're giving you something, but they're really giving you a nothing burger. Beyond that here, they're saying, hey, we're giving you benefits that are in excess. We're giving you more than you're entitled to, which is very interesting because there could be many things they're entitled to: overtime, materials, other things they were not paid for, not reimbursed for. So what they're trying to say is, hey, we're wiping out your claims for anything else we may owe you. So that's wiped out there. They're also giving a general release from claims. Now, once again, this is the big blockbuster, we are released from all claims, demands, actions, judgments, liabilities, expenses, blah, blah, blah. Every single contract out there in the world is going to have this waiver clause. I've written it 1,000 times, at least, not a million, but at least 1,000 times in contracts. Very, very, very standard. I don't think this would once again prevent them from any criminality or any regulatory action. Beyond that, there's a lot of other claims they try to get out of too. The Title VII. American with Disabilities Act, FMLA, Family Medical Leave Act, the Labor Standards Act, the Employee Retirement Income, the Civil
This is what I was talking about earlier, but he's going through it. They try to get out of all these things like the sexual harassment. If you leave, we aren't entitled to, maybe some of the disparagement or some of the disabilities, or any sort of issues you're bringing up in regards to any of these. We're not entitled. We waive all these things, and we're no longer at fault for it. No, you are. These aren't actually enforceable, and in fact, if they do treat you poorly, I can't remember the term, but the disparagement or anything like that, or go against you for any of these things, you're still able to bring lawsuits based on discrimination. There is no denying that. So if they violate any of these things, you can in fact be brought up still under these lawsuits. Okay, you could still file these could still be used against them. It's not like you just waved it away. It's not possible to do that.
Rights Act, the Worker Adjustment Act, the National Labor Relations Uniform Services, the Genetic Information Non-Discrimination Act, the Immigration Reform Act, the Texas Labor Code, the Whistleblower Acts in Texas and elsewhere, in Washington as well. We'll talk about Washington law later. A lot of these things that they are saying they're getting out of, they cannot actually get out of. If they truly violated those, even this agreement, they could come back on. So a lot of this is to make you believe that you're out of it, but whether or not that's actually effective, that is up to a court, and a court could decide, hey, no, you crossed the line, and in fact, we're going to hold you liable under those acts. They're also saying, hey, we're releasing all claims for compensation, tort damages, sick pay, any other attorney's fees, and trying to get out from anything. But what they even acknowledge here is, hey, in their own contract, they say, hey, there are certain types of claims and civil actions and enforcements, according to government agencies or courts, that you cannot get out of. And there are certain claims that cannot be waived by law. So even in their own contract, they tell on themselves. They really say, hey, there's certain things that can be claimed by law. And in fact, many of the things above, some of those can't entirely be disclaimed by a simple waiver, especially if the behavior was negligent or egregious. And in the case of VShojo, we may very well have negligent, egregious behavior. We've seen that with the leaks that are getting out there where, hey, it's looking like Gun Run knew. They knew. The leadership knew. At what point does it become grossly negligent, extremely negligent, or even willful, and just totally void this waiver, right? And
there's probably a whole lot that's voided within this waiver. The fact that they have you even coming out here trying to say that you waive this away, but then ultimately admitting that, hey, it actually doesn't work like that. That's insane to me. And even when it comes to some of the alleged things, like there's a lot of people that apparently knew what was going on behind the scenes, and potentially one of the talents that is not confirmed. I will not say that talent's name. All I will say is discovered that a talent was dating one of the executives, and more than likely knew what was going on there. That's all I'm going to say on that one. Was not expecting that little factor to come out.
That is a very good question. Next, they say, hey, you knowingly read this. You had your attorney look at it, right? You know what's going on here. That is something that is very, very important. You have ability to consult an attorney, because otherwise it would be under duress, right? But an even more important part here is non-disparagement. This is huge. And this is why a lot of the talents are probably wanting to stay silent, because they're looking at this covenant here, this promise where the employee agrees that they will not at any time, there's no expiration date on this, forever and ever, make, publish, communicate to any person, entity, or any public forum. That will be Twitter, X, that will be YouTube, that will be Twitch, that will be any other platform, saying anything defamatory or even disparaging. So disparaging can be true. Comments, statements concerning the employer's business or any employees now or in the future. So for example, if they were sexually harassed by an employee, they're expecting them to say silent? No, you don't have to. And this non-disparagement clause is what I hope that all the talents are speaking to their attorneys about, because what is non-disparagement is in the eyes of the beholder. What Gun Run may not want you to say, well, maybe you can say it because it was in fact illegal. Now,
I'm going to pause it here before we keep moving on, because that non-disparagement agreement, that actually might be what a lot of these girls are under, like the NDAs, some of the non-disparagement, some of the things they weren't allowed to go out there and say. If that's what the employees were under, imagine what the talents were under. Again, Silver Veil said her mother was even given an NDA. Think how strictly those were. Then simultaneously, when it comes to some of this stuff, and I don't know if he's going to get into this here, but he does get into it within the live stream itself. Again, I'm pimping out his live stream. Go check it out. He openly talks about how they basically give themselves permission, though, to attack you constantly, to deride you, to spread slander, to attack you. You have no ability to defend yourself or call it out. You cannot go out there and say anything against what they are saying. That goes to the non-disparagement clause, that goes to the NDAs, that goes to everything. They were putting everybody under these things. And that goes again back to what they treated Silvervale with. Bay, Nyanners, going around there, hiring a bunch of 4chan people, Mountain Dew, hiring a bunch of 4chaners to go around there and spread a bunch of lies and misinformation about them and disparage them. They weren't being allowed to fight back. Now it turns out even their own employees were under the same things. It wasn't just the talents, it was even their employees.
Here's a big one, and this is a giant one, which may or may not also be in the talent contracts. Jurisdiction, venue, and governing law. They put it under the law of Washington. That's very interesting, guys. Why would they put this under the law of Washington when they are a California company? Well, there's a reason for that, and that's because of choice of law. VShojo chose Washington over California because Washington has more favorable, less restrictive laws in California. The employment requirements are less. The wage and hour requirements are less. The non-compete clauses are okay in Washington. They're not okay in California. California has a broad prohibition against them. And despite all this choice of law, despite all this wrangling and gun runs, little tricks that his team put together, you can't escape some mandatory California labor laws even with this clause. But it indeed shows they were trying to be tricky with their choice of law. While they don't have any office there, their headquarters is in California, they decide to apply Washington law. Very interesting. Forum shopping, as we call it there. Going on here, there's no...
I am curious how that all plays out, because I was not aware of this, but they were forum shopping. There is a good chance that some of the girls are going to be forum shopping. It really depends on where they want to bring these lawsuits. Logically, they would probably want to bring it within California if you actually sit there and think about it, because again, those would be very favorable towards them. But when it comes to, Iron Mouse or Kason, depending on what they want to do, they could want to maybe bring Kason might want to bring in California. There's a chance Iron Mouse might want to bring it over in Puerto Rico, I think it was. No, I'm probably getting that wrong, but hey, that's me. I'm a dum-dum. That is actually something really fascinating to me, and I would love to see more of that get delved into, because is it actually okay for them as a California-based company to be bringing Washington law? I know I said that apparently a lot of companies do that, and that's something that even Legal Mindset said, because it's forum shopping. But is that actually legal, and how would these laws actually be applied? How does this all work out? I'm very curious here, and I'd like to see it. Real quick, Ombro, I do see that happening, and I don't know what the heck's going on there.
Admission of liability, so nobody's saying they're guilty. And this is very interesting. We have their attorney information, which is Odin Law at 4600 Marriott Drive, Studio 520 of Raleigh, North Carolina. So now we know their attorney. A lot of people have said, hey, their attorney was this, disbarred attorney or whatever, an attorney without a license. Well, no, they did have this drafted by these people. Now, the law firm, and I'm not disparaging them in any way, shape, or form, they look like a competent law firm. I've looked at their website. It looks fancy. I even think I may know somebody at that law firm potentially. I may have run into them at some point. But beyond that, they may have just gotten a template and filled out a template, which may be the case, right? That oftentimes is the case. So that's their attorney. They've got an attorney, Odin Law. And here's a very interesting one. If the employee breaches this, to the extent authorized by Washington law, the employee will be held responsible for payment of all reasonable attorney's fees that the employer incurred enforcing the terms. So what this means is they are attempting to threaten them with lawyers' fees if they do something like, for example, talk on X. That's one reason why all the talents are being careful. And I guarantee you, this clause is also in the agreements they're either trying to push in front of the VShojo talent or they already have, right? That is one that is definitely going to be there. So you can't modify this.
Think about that real quick. And I should have paused it. I was reading what you said there, Bro. But think about that, okay? That goes back to similar NDAs. You don't think some of the talents are under similar things? How would those NDAs be enforceable? Why are some of these girls still cautious about the NDAs? And I don't blame them for being cautious about the NDAs, but why do you think some of the stuff might not have been going out there that well? Why do you think some people weren't speaking up and, saying, oh my gosh, the company's evil, it's actually burning down and they're not paying us? Why do you think this was going on? To a lot of people that were out there saying, hey, why weren't you speaking up on this? Why weren't you coming out here saying anything? We need to prevent this from ever happening. You guys did the bad thing for not speaking up. In the contracts, even for employees, they were threatening that you would have to pay all the legal costs on us bringing charges against you, on us bringing claims against you, not charges, but claims, because this would be civil, not criminal. You would have to incur all the costs. Whether you win or lose, you'd still have to pay us all these costs. A normal person would look at that and go like, yeah, I can't speak because I can't afford that. I can't bring that. So, and I am calling a couple people out here. This is why people weren't breaking their NDAs, is because they were legitimately scared of this stuff. This is why people never spoke up. This is why people never fought back, because they were more than likely terrified of the fact that they could be brought into court and lose everything overnight based on just some of these laws. And these are for their employees. Think of how restrictive it was for the talents who they were willing to put mothers under NDAs for. Think about that and how that is actually going down there. That's insane to me that they were having these in the contracts, and the ramifications of that are nightmarish. No wonder people weren't speaking up. They were scared. They were being threatened.
By any other way, any other statements, any other method. And that's also very important, because what may happen here is a lot of times you may say, well, Gun Run told me.
Here, I'm going to go back real quick just because I did all that.
Is definitely going to be there. So you can't modify this by any other way, any other statements, any other method. And that's also very important, because what may happen here is a lot of times you may say, well, Gun Run told me in a DM, or maybe somebody told me somewhere else that this was going to be this way, right? Because they were probably promised something by other people and it just didn't pan out that way, right? Because a lot of times in staff situations, you'll have a manager tell you something, but that manager's verbal promise or email isn't really binding. What's binding is in a contract. So regardless of what they told you or promised you, talent first, right, guys? Talent first, right? That isn't necessarily how it will play out in the reality. And last but not least, we have the signature block. So you guys know this is legit. We have the signature block for VShojo and for the employer. So guys, this has a lot of potential value for the VShojo talent that may be trying to sign this, and also for employees in the past. What do you guys think about the contract? Do you think it's crazy? What do you think it is? Let me know in the comments below, and I'll catch you on the next one.
I think it's more crazy than what it might seem right now for a lot of you guys. And again, go check out his videos. Check out his live stream. It was a whole lot more in depth. He actually delved into this. It is interesting to see this, and it is interesting. I don't know, compared to some of the other VShojo topics out there, Mountain Dew and some of the other things that people could be talking about, this is contract law, and contracts get very, very boring. They're not that fun, and having somebody explain a contract to you is a whole lot easier than anything I could ever do, because I'd be looking at it and go like, I don't get it, I'm dumb. But the reason why this was actually important is, one, the non-disparagement, two, where they were deciding to position themselves for legal action and stuff like that, and then three, the threats. That little part there, the threat of, hey, if you speak out against us, if you violate this in any ways, you are going to be held liable, and you will potentially incur all this debt. You will potentially incur the blowback on us. And you have to think, that was for their employees. What's in the talents contracts? And we already have statements from Iron Mouse and some hints from other people. They were going out there and changing contracts after you sign it. How much worse could it be? And how much damages was VShojo trying to impose on their own talents? Talent first, my ass. But hey, I'm gonna leave this one here. We'll cover more VShojo stuff as it comes up.